Hi, welcome to the International Law Virtual Classroom. This module deals with the main features of the international crimes of genocide, war crimes and violations of the laws of customs of war, crimes against humanity and aggression, and individual criminal responsibility for these crimes. Students open the zip file with the annexes they need for the module International Crimes and Individual Criminal Responsibility. The text of the module is sent to them after the lecture. The Genocide Convention 1948 was a critical step in genocide being regarded as an international crime. But case law helped clarify many of the relevant principles. Students stop the tutorial 10 minutes and read Article 4 of the Statute of the International Criminal Tribunal for the former Yugoslavia and answer the question, what is the distinctive feature of the crime genocide? Genocide means any of the following acts committed with intent to destroy, in whole or in part, a national, ethnical, racial or religious group as such, killing members of the group, causing seriously bodily and mental harm to members of the group, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part, imposing measures intended to prevent births within the group, forcibly transferring children of the group to another group. The following acts shall be punishable: genocide, conspiracy to commit genocide, direct and public incitement to commit genocide, attempt to commit genocide, and complicity in genocide. Students stopped tutorial 10 minutes and read Article 2 of the Statute of the International Criminal Tribunal for Rwanda and answer the question, what is the distinctive feature of the crime genocide? Genocide is more than the act of killing. It is the intention which gives genocide its speciality and distinguishes it from an ordinary crime. The specific intention is thus required as a constitutive element of the crime genocide, which demands that the perpetrator clearly seeks to produce the acts charged. Difficulties arise in establishing the critical intent requirement in the absence of confessions. It is held that the person who incites others to commit genocide must himself have a specific intent to commit genocide. Students stop the tutorial 10 minutes and read the red paragraphs in the Goran Jelicic case and also listen to the video on the Jelicic case mentioned in the URL about the difficulties of proving genocidal intention. In the Jelicic case, the International Criminal Tribunal for the former Yugoslavia pointed to the difficulty in practice of proving the genocidal intention of an individual if the crimes committed were not widespread or backed up by an organization or a system. What is substantial is the intent to eradicate a group or a substantial part of the group as opposed to an accumulation of isolated individuals within it. The aim of the Genocide Convention is to prevent the intentional destruction of entire human groups, and the part targeted must be significant enough to have an impact on the group as a whole. The determination of when the targeted part is substantial enough to meet this requirement may involve a number of considerations. The intention to destroy means the physical or biological destruction of all or part of the group and not, for example, attacks upon the cultural or sociological characteristics of a group in order to remove its separate identity. What to do with forced migration? Does forced migration constitute genocide? Forced migration or ethnic cleansing as such does not constitute genocide, but it may amount to a pattern of conduct demonstrating genocidal intent. What to do with rape and sexual violence? Does rape and sexual violence may amount to genocide? Rape and sexual violence may amount to genocide when committed with the necessary specific intent to commit genocide. War crimes are essentially serious violations of the rules of customary and treaty law concerning international humanitarian law. Students stop the tutorial 10 minutes and read Article 2 of the Statute of the International Criminal Tribunal for the former Yugoslavia. What is the distinctive feature of war crime? Article 2 of the Statute of the International Criminal Tribunal for the former Yugoslavia provides for jurisdiction with regard to grave breaches of the Geneva Conventions of 12 August 1949, namely the following acts against persons or property protected under the provisions of the relevant Geneva Convention: willful killing, torture or inhuman treatment, including biological experiments, willfully causing great suffering or serious injury to body or health, extensive destruction and appropriation of property not justified by military necessity and carried out unlawfully and wantonly, compelling a prisoner of war or a civilian to serve in the forces of a hostile power, willfully depriving a prisoner of war or a civilian of the rights of fair and regular trial, unlawful deportation or transfer or unlawful confinement of a civilian, and taking civilians as hostages. Students stop the tutorial 10 minutes and read Article 3 of the Statute of the International Criminal Tribunal for the former Yugoslavia. What is the distinctive feature of violations of the laws or customs of war? Article 3 provides for jurisdiction for violations of the laws or customs of war. Such violations include, but are not be limited to, employment of poisonous weapons or other weapons calculated to cause unnecessary suffering, wanton destruction of cities, towns, or villages, or devastation not justified by military necessity, attack or bombardment by whatever means of undefended towns, villages, dwellings, or buildings, seizure of, destruction, or willful damage done to institutions dedicated to religion, charity, and education, the arts and sciences, historic monuments and works of art and science, and plunder of public or private property. War crimes are a discrete part of the principles of international humanitarian law. Essentially, war crimes law applies to individuals, and international humanitarian law applies to states. Traditionally, international humanitarian law distinguished between international and non-international armed conflicts. However, since the conflict in Rwanda, which was clearly an internal one, the Statute of the Criminal Court provided for individual responsibility for violations of the principles in the case of non-international armed conflicts. Students stop the tutorial 30 minutes and read the 1997 Dusko-Tadić judgment and answer the question: what is the distinctive feature of the crime, war crime? Which circumstances were relevant to sentencing him for each of the crimes? The Tadić case before the International Criminal Tribunal for the former Yugoslavia laid down the main principles. International humanitarian law applies from the initiation of armed conflicts between government authorities and organized armed groups, or between such groups within a state. The distinction between international and non-international armed conflicts was thus minimized. Individual criminal responsibility existed with regard to violations laid down in customary and treaty law, irrespective of whether the conflict was an international or an internal one. A significant number of provisions dealing with international conflicts now apply to internal conflicts as laid down in the Statute of the International Criminal Court. The accused Duško Tadić was a Bosnian Serb. He was indicted on counts of crimes within the jurisdiction of the International Tribunal for his actions in the Prijedor region and detention camps. On the 7th of May 1997, he was found guilty of crimes against humanity and of violations of the laws or customs of war. The sentencing judgment recalls that the crimes consisted of killings, beatings, and forced transfer by accused Tadić as principal or as an accessory, as well as his participation in the attacks on the town of Kozarac in Prijedor in northwestern Bosnia. Significant number of provisions dealing with international conflicts now apply to internal conflicts, and the perpetrators are held individual criminal responsible irrespective of whether the conflict was an international or an internal one. It was concluded that in order for Article 3 of the Statute of the International Criminal Tribunal for the former Yugoslavia to be applicable, the violation had to be serious. Serious means that it had to constitute a breach of a rule protecting important values and that the breach must involve grave consequences for the victim. In addition, the violation of the rule must entail, under customary or conventional law, the individual criminal responsibility of the person breaching the rule. Students stop the tutorial 10 minutes and read Article 6 of the Nuremberg Charter. Article 6 of the Nuremberg Charter included crimes against humanity, defined as murder, extermination, enslavement, deportation, and other inhuman acts committed against any civilian population before or during the war, or persecutions on political, racial, or religious grounds in execution of or in connection with any crime within the jurisdiction of the tribunal, whether or not in violation of the law of the country were perpetrated. Students stop the tutorial 10 minutes and read Article 5 of the Statute of the International Criminal Tribunal for the former Yugoslavia and answer the question: what is the distinctive feature of crime against humanity? Students stop the tutorial 10 minutes and read Article 3 of the Statute of the International Criminal Tribunal for Rwanda and answer the question: what is the distinctive feature of crime against humanity? The crimes against humanity, when committed in armed conflict, whether international or internal in character, are directed against any civilian population and include murder, extermination, enslavement, deportation, imprisonment, torture, rape, persecutions on political, racial, and religious grounds, and other inhuman acts. The crimes are committed as part of a widespread or systematic attack. The requirement of widespread or systematic was examined in the Tadić trial. Proof that the attack was widespread or systematic are legal elements of the crime. The existence of a policy or plan could be relevant, but it was not a legal element of the crime. The requirement of widespread or systematic in the case of Akayesu was defined as massive, frequent, large-scale action carried out collectively with considerable seriousness and directed against a multiplicity of victims. While systematic was defined as thoroughly organized and following a regular pattern on the basis of a common policy involving substantial public or private resources. It was noted that there was no requirement that this policy must be adopted formally as the policy of a state although there had to be some kind of preconceived plan or policy. The crimes against humanity are against any civilian population. Also, the requirement of directed against any civilian population was examined in the Tadić trial as meaning that the acts must occur on a widespread or systematic basis, that there must be some form of governmental, organizational, or group policy to commit these acts, and that the perpetrator must know of the context within which his actions are taken. The crimes are thus committed with knowledge of the attack. What is required for crimes against humanity is an attack defined as an unlawful act of the kind enumerated in Article 3 of the Statute, like murder, extermination, enslavement. An attack may also be non-violent in nature, like imposing a system of apartheid, which is declared a crime against humanity in Article 1 of the Apartheid Convention of 1973. What is distinctive about crimes against humanity is that they do not need to take place during an armed conflict. However, to constitute crimes against humanity, the acts in question have to be committed as part of a widespread or systematic activity, and to be committed against any civilian population, thus any reference to nationality is irrelevant. Any act of genocide by definition will constitute also a crime against humanity. However, a crime against humanity will not necessarily constitute genocide. Article 6 of the Nuremberg Charter defined its jurisdiction as including crimes against peace, namely planning, preparation, initiation, and waging of a war of aggression, or a war in violation of international treaties, agreements, or assurances, or participation in a common plan or conspiracy for the accomplishment of any of the foregoing. A number of defendants were convicted of offences under this head. The General Assembly Resolution 95 and the Tokyo Charter affirmed the principles recognized by the Nuremberg Charter. Students stop the tutorial 10 minutes and read Article 5 and Article 8 bis of the Statute of the International Criminal Court and answer the question: what is the distinctive feature of the crime aggression? The court could not exercise jurisdiction over the crime of aggression until a provision was adopted, defining the crime and setting out the conditions under which the court may exercise jurisdiction with respect to it. This was finally done by a resolution of the Review Conference in June 2010. The act of aggression means the use of armed force by a state against the sovereignty, territorial integrity, or political independence of another state, or in any other manner inconsistent with the Charter of the United Nations. Any of the following acts qualify as an act of aggression: the invasion or attack by the armed forces of a state of the territory of another state, or any military occupation, however temporary, resulting from such invasion or attack, or any annexation by the use of force of the territory of another state or part thereof. Bombardment by the armed forces of a state against the territory of another state, or the use of any weapons by a state against the territory of another state. The blockade of ports or coasts of a state by the armed forces of another state, and an attack by the armed forces of a state on the land, sea, or air forces or marine, and air fleets of another state. The Security Council has the competence under Chapter 7 of the Charter to determine whether an act of aggression has taken place. Students stop the tutorial 20 minutes and read the following articles. Article 21 of the Statute of the International Criminal Tribunal for the former Yugoslavia. Article 20 of the Statute of the International Criminal Tribunal for Rwanda, and Article 55 of the Statute of the International Criminal Court. What are the fair trial provisions guaranteeing the protection of the human rights of the accused? Article 55 of the Statute of the International Criminal Court lays down the rights of persons in respect of an investigation. A person shall not be compelled to incriminate him or herself or to confess guilt. A person shall not be subjected to any form of coercion or degrading treatment or punishment. A person shall have, free of any cost, the assistance of a competent interpreter. A person shall not be subjected to arbitrary arrest or detention. Where there are grounds to believe that a person has committed a crime within the jurisdiction of the court, that person shall have the right to be informed, to remain silent, to have legal assistance, and to be questioned in the presence of a counsel. In addition, Article 66 of the Statute of the International Criminal Court provides for the presumption of innocence. It is for the prosecutor to prove the guilt of the accused beyond reasonable doubt. Article 67 of the Statute of the International Criminal Court guarantees the rights of the accused. Students stop the tutorial 20 minutes and read the declaration lodged by Ukraine over alleged crimes against humanity committed on its territory in the context of the Maidan protest and other events in Crimea and eastern Ukraine, including murder, torture, and other inhuman acts. Students are assigned a case sent to them by email. They should send their answer by email to the lecturer by the end of the day. The lecturer will correct the answers of the students and send it back with the corrections.